Law&Crime. This court. Elena Ortega awoke in the darkness of her own home. A stranger was in her room. She barely made it past the edge of her bed when she felt a strike of the first blow to her right eye. The force of that blow spun her around, and her body, the top half of it, ended up on the mattress in the bedroom. Seconds passed, and Elena Ortega tried to gain her bearings. Her 83-year-old body struggled and searched for her bearings in the darkness. At that same time, during those same seconds, the stranger searched for a weapon. When the stranger found the weapon, Elena Ortega looked up at him and told him, "You don't have to do this." Elena Ortega knew she was about to die. The stranger gets the first blow down with the weapon. She puts her hands up and she can't stop it. Her skull fractures. And then the second blow. And then the third. At this point, her head falls to the mattress, but she's still conscious. For the next 15 minutes, Elena Ortega listens as the stranger rummages through her property in her home. She hears him pull the suitcases out of her closet.
Object. This is an evidence in this case.
Sustained. Rephrase it, please.
The evidence indicates that she was conscious, or could have been conscious, as the suitcases were pulled out from her closet. She hears as dresser drawers are dumped and property from her home are put into those suitcases.
Me and Judge, I'm not objecting. These are matters of narcotic evidence.
Overruled.
Elena Ortega is alive when the stranger leaves. And she's alive when he returns a few minutes later. She's alive when her home is set on fire around her. Her home of more than 20 years. Until eventually she succumbs to multiple skull fractures and to the inhalation of carbon monoxide from the fire that burned. Ladies and gentlemen, these are the facts that you have heard in this case. When we started, they were allegations and they have now been proven. Those facts with one more. That the stranger in the darkness, the stranger in her home on the night of September 18th of 2013 was this defendant, Juan Rosario. You have now heard all of the facts been presented to you. The only thing remaining is for us to spend a few minutes to talk about the law and how those facts will fit. So let's take a couple moments to do that. We're going to start with the crime of arson of an occupied structure. And you've all been provided copies of the instructions. You should feel free to follow along, but you're not obligated to. That's on page 9. The state has to prove two elements to prove arson of an occupied structure beyond a reasonable doubt. The first element is that Juan Rosario willfully and unlawfully caused the fire. Now, as we go through the elements of each of these crimes, the word Juan Rosario is going to appear in the elements. I'm going to hold off to discuss that at the end. In other words, we have to prove for each crime that this defendant is the man who committed it. And we'll talk about that at the end. So, the first element, the substance of it is that it was willfully and lawfully caused a fire. Below that is described through that willfully means intentionally, knowingly, and purposefully. So, what evidence do we have that the fire set at Elena Ortega's home was intentionally, knowingly, and purposefully set? You have the testimony of Fire Marshal Nick Incontrera. He told you that he arrived on the morning of the 18th and went through and looked at the scene. You took photographs, and you saw the photographs, and they're now in evidence. Specifically, Mr. Incontrera told you that when he went through the home, there were no accidental sources of that fire. He looked at the washer and dryer in the photograph on the screen. He looked at outlets. He looked outside at the boxes for electrical power, and he found no accidental sources. More significantly, he found 3 independent, non-communicating points of origin of that fire. And he told you where they were. One in the hallway, one in the washroom, and then one in the sewing room around the corner. And he told you that it was his opinion that it was the ignition of ordinary combustibles by open flame that started those. It was his opinion that those fires were intentionally set. The second element the state has to prove is that the structure, the person who started that fire knew or had reasonable grounds to believe it would be occupied by a human being at the time of the fire, and that the structure was actually damaged by the fire. You've seen multiple photographs that show the damage to the fire, and I won't show them to you again. So that goes back to reasonable grounds to believe it would be occupied by a human being. I point you directly to State's Exhibit 5 and photograph P4 of State's Exhibit 5. If you recall, that photograph was taken at the entry, or just to the right of the entry to the victim's bedroom, and just to the right of that photograph is the closet where the fire was set. Whoever set that fire in the closet would have been looking directly into the bedroom where Elena Ortega's body was laying. Evidence that the person, Juan Rosario, knew or had reasonable grounds to believe that the structure was occupied. Now, of course, you have the defendant's statements to Janet Gutierrez, and we'll talk about that when we talk about identification. So that's arson of an occupied structure, which brings us to first-degree murder. And we'll start by talking about premeditated first-degree murder on page 4 of your instructions. The first element of premeditated first-degree murder is that Elena Ortega is dead. And you've heard testimony about that fact, but the state and the defense have both stipulated and agreed that that fact is proven, and you can accept that stipulation. The second element is that the death was caused by the criminal act of Juan Rosario. We'll talk about that in a moment. And the final and third element is that there was a premeditated killing of Elena Ortega. Now, premeditation, and remember we talked about this in jury selection, we asked you to forget what you thought premeditation was and listen to the law as the judge instructed you. Premeditation is killing after consciously deciding to do so. The law does not fix the exact period of time that must pass, but it must be long enough to allow reflection by the person who does the killing. So this is the example that I would use for you of premeditation. Anybody who's lived in Florida will know what I'm talking about. A mosquito on a summer day lands on a person's arm. You look down, you feel the sting, and you have a decision to make. You can either brush that mosquito off, and it lives, or you can decide in that moment to slap it and squash it. And ladies and gentlemen, that is all that's required for premeditation. Consciously deciding to kill with enough reflection to do so. There is no requirement of planning, advance notice, hiding in bushes. and it's consciously deciding to do so. So, what evidence do we have of premeditation in this case? So we're going to start with the testimony of Dr. Sarah Zadovich, the Associate Medical Examiner in the case. Because I relayed those facts to you in the very beginning of this closing argument, not for dramatic effect, because they matter for premeditation. Dr. Zadovich testified to 4 separate strikes to Elena Ortega's head. The first, if you recall, is the strike to the eye, which left bruising but did not fracture any part of her face. She testified that it was possible that that was a fist or a hand, and she told you that she did not believe, in her opinion, that that was any type of blunt object. She also testified subsequently to at least, she used the words, a minimum of 3 additional strikes to Miss Ortega's skull on the right side. And she told you that those were different than the one that struck her, or the one that struck her in the eye, because they were consistent with an object. Remember, she described to you, she said it was not a hammer, it wasn't specific enough to be a hammer, but it was an object similar in nature that could summon all the force necessary to come down and create the damage on Miss Ortega's skull. Now, the 3 strikes, the significance of those are the timing. Because we talked about time to reflect. Each one of those strikes takes a conscious effort. Down, one time. A decision in the mind of Juan Rosario to come back up and come down again. To come back up and come down again. The passage of time allows for that consciousness to build. And that is exactly what happened, according to the evidence, on the morning of September 18th. Struck her with such force that her skull actually caved in onto her brain, called a depressed skull fracture. The reason we know, ladies and gentlemen, that she was on the bed when she was struck is because there was no blood anywhere else. There was no blood in the hallway. There was no blood on the wall. All of the blood in this scene was on the bed. And you are not to forsake your common sense when you view and listen to the evidence in this case. It was 5 a.m. Elena Ortega most likely asleep. Someone comes in her room, and according to the positioning in the photographs, she would have had to have been right near the bed because, if you recall, she could not walk well. The function of her 83 years, hip replacement surgery, and bowel or stomach surgery not long before that. Walkers placed throughout her home to make sure that she can get around. She didn't have a chance to get very far. So that first strike, we know that's the first strike because it would not have completely incapacitated her, according to the testimony. All the subsequent strikes would have. And if she had been struck with those other strikes anywhere else, we would have evidence of blood somewhere else in the room or in that home. And there was none. So, as I told you when we started, what that tells us is that Juan Rosario repeatedly struck her while her head was on her own bed, as she lay defenseless. The other evidence that we have of premeditation is the setting of the fire. Because recall from Dr. Zadovich that the cause of her death was not simply the skull fractures and bruising and damage to her brain, but the result of 29% of carbon monoxide poisoning in her blood. We know, according to the testimony, that Juan Rosario went back to set that fire. And the going back is yet again an intention to end her life, as he directly stated to Janet Gutierrez. And we know that's the sequence of events because of the testimony of the crime scene technician, Joanna Fletcher, who pointed out to us the significance of the voids on the bed. Because Juan Rosario pulled the dressers out searching for money or valuables before he set the fire, allowing those voids to be left behind. And I wasn't just talking about suitcases in the closet. There's evidence of it, because if you look at that photograph, the closet doors are open, things are strewn out, and if you recall the testimony from Elena Wilson, her mother kept her fabric suitcases in her closet in her bedroom. So the other evidence of premeditated murder, forensically, is the setting of the fire. And I would point out at this point that all of that evidence of premeditation comes without any testimony from Janet Gutierrez. We'll come back to that. So that leads us to the other type of first-degree murder, felony murder, on the following page 5 of your instructions. Again, the first element, Elena Ortega is dead. We talked about the stipulation. Number 2, while engaged in the commission of a burglary, Juan Rosario caused the death of Elena Ortega. And number 3, Juan Rosario was the person who actually killed Elena Ortega. Again, number 3 is ID. We'll talk about that at the end. So as you can see here, right below what I just read to you, is that the difference between premeditated murder and felony murder is that we don't have to prove the intent to kill. Now, it's not clear by now, let me make it clear. We believe the evidence has shown, without question, that this murder was premeditated. But there are 2 ways to prove first-degree murder, and we would submit to you that we have done both. So let's talk about element number 2. While engaged in the commission of a burglary, Juan Rosario caused the death of Elena Ortega. So that means we have to prove burglary, which is right below. The first element of burglary, Juan Rosario entered a structure owned or in possession of Elena Ortega. Of course, there was testimony that Elena Ortega lived at 5020 Turnbull Drive for many, many years. It was in her possession. You heard that she routinely locked the doors and windows. And candidly, we don't know if she did that night because the windows were pulled out before anybody could really examine them. We do know that the front door was open at the time. But we don't know if Juan Rosario just went out the front door and left it in the state that it was when Ariel Jakubowicz found it. But we know he entered a structure because he ended up coming back with property from her home, inside her home. And we know, again, aside from Janet Gutierrez's testimony, that he had that property because it was found in his backyard and in the dresser inside the bedroom where he slept. Number 2, at the time of entering the structure, he had the intent to commit theft in that structure. I just talked about the items that were taken from her, or from her home. I would point you or direct you to the paragraph that begins proof of possession. What that paragraph tells you is that if a person is found with recently stolen property and it's not satisfactorily explained, it may justify a conviction of burglary if the circumstances of the burglary and possession convince you beyond a reasonable doubt. And then finally, the paragraph below, you can infer that Juan Rosario had the intent to commit a crime in that structure if it was done stealthily and without the consent of the owner. And we know, according to the evidence, ladies and gentlemen, that Juan Rosario stealthily entered her residence because of where she was found. She never had the opportunity to go anywhere. She did not encounter him or know he was there until the last minute. Evidence aside from the testimony of Janet Gutierrez, proving beyond a reasonable doubt the elements that the state has to prove both for arson, first-degree premeditated murder, and first-degree felony murder. So, I'm going to talk to you briefly a little bit more about some other law. There's an instruction on page 10 that says when there are lesser included crimes or attempts. So what the law says is that if we do not prove, or if there is not evidence beyond a reasonable doubt for the highest offense charged, then you may then consider lesser included crimes. I'm going to touch on them briefly, though I have already told you that the evidence in our views proves first-degree murder and arson of an occupied dwelling. So the lesser crimes of first-degree murder are second-degree murder and manslaughter. The difference between first-degree murder and second-degree murder is premeditation. That's the difference. First-degree murder proves that there was an intention to kill. Second-degree murder is that there was an intentional act with a depraved mind. Those are the differences. And because I've already talked about first-degree murder and the evidence of it, I'm not going to discuss second-degree murder any further. Manslaughter merely requires an intentional act that is culpable negligence. We would submit to you that what was done in this case is far beyond that. The lesser included crimes of arson of an occupied dwelling, there is an arson charge and a criminal mischief. I'm not going to go through them because the arson is complete, but you have now been told why those charges are there. And specifically on page 10, you are told that lesser included crime is only appropriate if the main accusation has not been proven. The main accusation is in this case being first-degree murder and arson of an occupied dwelling. And you should find a verdict of guilty for the highest offense, and you find evidence beyond a reasonable doubt. The final point or instruction that you received that I'll touch on is found on page 3. And it's titled Excusable Homicide. It talks about when a homicide or the killing of another is excused. And I would just ask you to briefly look at the first few words of each of paragraphs 1, 2, and 3 below that, because they all start the same. When the killing is committed by accident and misfortune. And we would submit to you that what was done to Elena Ortega on September 18th was not an accident, and there was no misfortune. That was intentional and premeditated. So we would tell you that, or ask you to find that instruction is not applicable. Okay, so we've talked about the forensic evidence, the elements of the crime. So now we're going to talk about how you know Juan Rosario is the perpetrator of this crime. How you can know that beyond a reasonable doubt. And we're going to talk about Janet Gutierrez. Because I suspect, ladies and gentlemen, that this is a real dispute in this case. Is, did Juan Rosario commit this crime? Not whether it happened or not. So there is circumstantial evidence, aside from Janet Gutierrez, that Juan Rosario is the murderer. His proximity to her address is one thing. And I've already touched on the fact that her property was found in his room and buried in the backyard of the residence where he stayed on September 18th of 2013. I would also point you to the mop found in his home, just outside his home in the carport, that had human blood on it. But that brings us to Janet Gutierrez. Because the state would submit to you that if you believe the testimony of Janet Gutierrez, you have all you need and more to convict Juan Rosario of first-degree murder and arson. So then, that begs a natural question. How can Janet Gutierrez be believed? You heard defense counsel's opening statement. You heard her testimony. She's called an addict. She's a convicted felon. And she admits to loving the defendant at the time and for some time after this crime was committed. So, what was not addressed is all of the testimony and evidence that supports exactly what she said. So we're going to talk about that for just a few moments. What elements of Janet Gutierrez's testimony were corroborated by other independent evidence that allows you to have confidence in what she says? She told you that late hours of September 17th, early morning hours of September 18th, the defendant, her boyfriend, asked her for money. We know that Juan Rosario wanted money because that's what he came back from Elena Ortega's home with. The cash from one of the photographs, behind one of the photographs in her bedroom, and of course the property that has been discussed and displayed. We know, or Janet Gutierrez testified that when she awoke in her bedroom, and then more specifically when she saw the clothing in the light, that the defendant's clothing had blood spatter on it. And that were drops of blood, or there was blood in the hallway that she mopped up. That, of course, is consistent with the crime scene evidence that you've seen in the testimony of Dr. Sarah Zadovich. Because she testified that those were, quote, open skull fractures. The way in which Juan Rosario murdered Elena Ortega lent itself to exactly the evidence that Janet Gutierrez witnessed. Because after the first skull fracture, her brain and underneath her skin was exposed, and the second strike...
Objection.
Let me see the attorneys at the bench. You may proceed, Mr. Rollins.
Thank you, Your Honor. No expert testified that there was blood spatter. But we know from the injuries that Elena Ortega suffered to her head that there were open skull fractures. And that lent itself to the blood spatter that Janet Gutierrez saw on the defendant on the morning of the 18th. What else did Janet Gutierrez testify to? She told you that when she woke, the defendant told her he robbed an old lady. The victim in this case was, of course, 83 years old. How would she know that? She told you that the suitcases he was carrying had a floral pattern on them, and the fabric in nation, which is exactly the way that Elena Wilson described the suitcases that her mother owned and that were in the closet where he took them from. She said that Juan Rosario told her, she saw my face, I have to go back to kill her and to get rid of the evidence. The fingerprints are everywhere. We know that the house was set on fire, just as she described it, and that the sequence of events was the same. In other words, that he came back, described the murder, and then went back and set the fire. And we know that is the sequence because of the voids in the mattress and around the home. She said that following him leaving and taking off his clothes, she mopped up the floor. Through her testimony from crime scene technicians who collected the evidence and did presumptive testing, and then from Tim Petrie, the Florida Department of Law Enforcement, that when he tested the mop, which, by the way, matches the description that Janet Gutierrez gave, that there was human blood on that mop. These are all things that Janet Gutierrez testified to, corroborated independently by other sources. She told you that she bagged the clothing and that morning she was going to work and catching a ride with her boss. And Edgar Concepcion came in and testified that he remembers one time when he picked her up in the morning and she had trash bags. These are not coincidences. She told you that she buried the items in the backyard, and that in her rush to abide by the defendant's order, she forgot where one of the bags was. And 9 months later, the Orange County Sheriff's Office went out to the backyard of 4756 and found exactly what she described. And if you recall, she described exactly what the makeup bag looked like. A small bag with a flower pattern, which of course is exactly what was inside the bag, because Janet Gutierrez was telling the truth. She told you that following this crime, just to make clear that this was Elena Ortega's makeup bag, she told you that following the crime, the defendant was hiding out in hotels that were being rented in other people's names, and that one of those people was his sister, Elizabeth Garcia. And Detective Thorpe testified that during his follow-up investigation, he found that Elizabeth Garcia, same address, rented a room with cash, mere miles from their home. Why would they need to rent a hotel room 2 miles from their house? Because they were hiding Juan Rosario. So now, briefly go back to the intent elements of murder and arson that we have to prove. Because all of that evidence and testimony now allows you to believe Janet Gutierrez. And she told you that on that morning, the defendant told her he had to go back to kill her. His words. Had to go back to kill her to get rid of the evidence. And to be fair, he was very successful at doing so, because they scoured that house for any trace that he'd been there. And there was no trace that he or anyone else had been there, because he burned it. Even, ladies and gentlemen, if Janet Gutierrez was the only witness in this case, and of course she's not, based upon her corroborated testimony, you have everything you need to find this defendant guilty. Now, in a moment, I'm going to sit down and Mr. Lee will have the opportunity to address you with his closing argument. And I would ask you to listen carefully to it because it will be followed by Ms. Vera, who will do the rebuttal closing for the state. Please listen carefully to the defense argument, and specifically, listen for specific words, like maybe, possibly, could be, because those are your invitations to
Objection to
speculate.
integration.
Overruled. Go ahead.
Those are your invitations to speculate. So I would hearken you back to the definition of reasonable doubt that is in your instructions and that was discussed from the very moment some of you walked into the courtroom last week. A reasonable doubt is not a mere possible doubt. A forced, imaginary, or speculative doubt. And such a doubt should not cause you to render a verdict of not guilty as long as you have an abiding conviction of guilt. So please listen carefully to the arguments that the defense counsel makes. And then I ask that you listen as Ms. Vera has an opportunity to rebut them. And then I would ask that when she sits down, you do what I know she will ask you to do, which is to return a verdict of guilty as charged of all the crimes in the indictment. Thank you.
Thank you, Mr. Williams. Ladies and gentlemen, do you need a break of any kind before closing?